Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, a citizen of Godfrey, the fifth caravan of Jews, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know in the third typical English Church of England. He is our Jesus Christ, which we know is the King of Peace. It is what is the date? Let me just make sure I get that. I have to use it show me. Hold on for a second. Hello?
Hello. Am
Hello.
I speaking with Clifford Jefferson?
Yes, this is him.
Hello, Clifford. My name is Leah from Mexico. How are you today?
Pretty good.
Oh, that's great. If you could, the reason for my call is for me to offer you a brief information for scripture. This will help you to reduce your monthly electric bill less than 95%. So, sir, are you interested to see how much you can save?
No, thank you. Sorry about that, everyone. All right. Sorry about that. They're going to know this is going to be a good lesson, so they're trying to interrupt me. So let me start over. It is Wednesday the 7th, 2024, birth year 2974. I am King Edgar the Peaceful, reincarnated in this present day as Clifford Jefferson, which we know after the third English Church is Jesus Christ. I am descendant of Godfrey the fifth caravan Jew, son of folk, ruler of Jerusalem. I'm here with another marvelous lecture that you cannot deny. All right. And this lecture today is for all those who do not realize that whether you want to or not, or whether you agree or not, you are subject to a position in the contract where you have little say of the matter. All right, you have little say of the matter. Give me 1 second, just make sure my screen is all right. Bear with me. All right, let's try it again. All right, once again, this is a lecture on the unconscionable contract that we are subject to because we are unconscionable about who we are. Okay, you know, we're not in a position to be able to be in a position to make contracts or even perform to a contract because of our position. All right, we are presumed to be what we call debtors. If you watch my last lecture, okay, then this is one's going to be a doozy. All right, I'm going to use some of the same references that I did in my past lecture, but I just do this to bring it clear to you to understand that you truly are subject of the crown. Okay, you're truly a subject of the crown, and you need to know and understand what the crown is and the part you play at being part of the crown's estate, because you are indeed heirs to the estate. Okay, but let's deal with some basics that we need to understand in regards to the contract, in regards to the states, United States, the colonies, as well as all those who are allowed to come in by what we call migration or immigration, uh, or whether it was by what we call acquisition of sovereignty, prescription, right of discovery, right of conquest. All these are forms of uh, land tenures that exist here, which are based upon contractual agreement. But we know that the original grantor, in lieu of the contractual agreements that deal with feudal land tenure estates, is none other than the crown. Okay, We must understand that. So once again, that's going to be my focus point. And we understand that the crown gets free and common soakage. We all are indebted to someone. Okay, we all are indebted to someone. We are indebted to God. All right, your abstract concept. In our world, we are indebted to the king or the crown or the minor. All right. In this case, it would be, or in your case, it would be what we call the state or the federal government. Because in order to participate in the commercial aspects, you must pay that fee, and that fee is that tax. Okay. That fee is that tax. All right. So I know a lot of us are upset about the taxation. We know taxation without representation is a violation of law. That was the colonies' problem in their founders. They didn't want to pay that debt. Okay. Whereas you are not debtors. Your positions are creditors, but you lack that understanding, which limits your bargaining power. All right. As a result of duress and undue influence, which is a psychological control over your mental state, and as a result of your legal standing in law. Okay, and this is where your due process of law comes in. All right. So without further ado, I'm going to show you a small clip. The reason why I chose this clip outside of the language that's going to be used is because a lot of us, this is how we express ourselves when we're upset about the taxation, the encumbrances that we have in our everyday life as a result of not being on the fair ground or fair standing and as other members in society. All right. Especially those who were the founders of society, i.e. the English people. So this is how a lot of us react when we think in our private time, or some in our public time, and some out there we constantly see it on the internet. People are upset about their condition. The citizens are upset about their conditions. The nations are upset about their condition, not just here, but around the world. And the effects of that is not knowing your part to play, which gives you the result that you have, because the part you're playing is not the part you should be playing. All right. And this is what I come to bring to fruition for all the English heirs of succession. For everybody else, I can't speak for, because you have your own mother, you have your own father nation that you must go back for your birthright. Okay? Your own nation gives you the right to derive your what we call birth certificate. All right? Your right to be able to live in society protected by that society, i.e., that body of politics. It's all uniform. Okay? So without further ado, I don't want to hold you long, so let's get started. All right? Excuse the language. American taxes be like. Some of y'all, this is from TikTok, so all those familiar with TikTok, that's a popular site. You know what I'm saying? And they have a lot of information on there, a lot of damaging information, but this information I'm giving you is not the damage is actually correct. The damage has been done. A way of exposing a lot of the concerns that we find ourselves in today based off the example that they put on TikTok. Okay, so without further ado, let's get started.
My paycheck and taxes, most definitely. And then after you tax so you're gonna take 40% of my paycheck in taxes, most definitely. And then after you tax my check, you're gonna tax me on anything I spend with the money left from my check that you already taxed. Oh, you getting it now? You this close? You this close to getting ready to chase the American dream? So let me get this shit straight, bitch. You gonna tax my whole check? Give me what's left. Then I'm gonna spend that on something, and you're gonna tax me again for spending money that was already taxed. And after I buy something, I have to pay taxes on that. Whereas you're gonna take it from me because I didn't pay taxes. Yes, and if you do that real hard and just pull up on your bootstraps with all your might, you will make it in this country. Bro, that sounds like some fucking bullshit. If I gotta pay taxes on anything that exists forever, anytime, always, every day, or else I fucking get my shit took or go to prison, do I own anything? No, y'all don't own shit. It's just a big lending system. We own everything, and we just sell you the illusion that you got something. You don't have shit. Miss a tax payment, I'm taking that shit. Miss another one, I'm taking your fucking life. You're going to prison. Don't like it, leave.
Okay, we're gonna run that back real quick. All right.
So you're gonna take 40% of my paycheck in taxes? Most definitely. And then after you tax my check, you're gonna tax me on anything I spend with the money left from my check that you already taxed. Oh, you getting it now? You this close? You this close to getting ready to chase the American dream? So let me get this shit straight, bitch. You gonna tax my whole check? Give me what's left. Then I'm gonna spend that on something, and you're gonna tax me again for spending money that was already taxed. And after I buy something, I have to pay taxes on that, or else you're gonna take it from me because I didn't pay taxes. Yes, and if you do that real hard and just pull up on your bootstraps with all your might, you will make it in this country. Bro, that sounds like some fucking bullshit. If I gotta pay taxes on anything that exists forever, anytime, always, every day, or else I fucking get my shit took or go to prison, do I own anything? No, y'all don't own shit. It's just a big lending system. We own everything, and we just sell you the illusion that you got something. You don't have shit. Miss a tax payment, I'm taking that shit. Miss another one, I'm taking your fucking life. You're going to prison. Don't like it, leave.
Now, for some of y'all, that might be amusing. All right? That might be amusing, but it's not amusing. It's not something that you should be laughing at, because this is a serious matter. Okay? This is a very serious matter that must be addressed. Okay? It must be addressed. Let me just go here for a minute. For all those who didn't see this in my last lecture, I'm going to pull it up again so that you all can see it from a real estate book, okay, of New Jersey. Okay. I showed this in my last lecture, so if you didn't see it, go back and watch it. All right. This is the real estate book. Let me just show you the book. Right there. Everybody see that? Essentials of New Jersey real estate. Okay? We must understand that. All right? We must understand that. All right. Okay. Let's read this right quick. Remember legal terminology, or versus E. Throughout this chapter and the rest of the book, we will refer to the people as grantor and the grantee, trustors or trustees, mortgager or mortgagee, and so on. Because the terminology can be confusing, we included this table to help you remember who's who in transaction, i.e. a contract. Refer back to this table when the term comes up in chapter 2, all right? Note that a mortgage is a written agreement that pledges real estate as a security for the payment of a debt. The mortgager is the borrower. This person, the mortgager, gives the mortgage, the lender, a mortgage or a deed of trust, property interest on the property used to secure a loan. So it's a pledge. Okay? Everybody needs to understand that. It's a pledge. As you can see here, chain of title. Chain of title. Page 267. When dealing with owner of real estate, a purchaser, we ain't talking about land. We're dealing with real estate, parcel, estates that are only come in three forms: fee simple, fee indeterminable, and life estates. All right. These all deals with estates that were sold or subjugated. All right, through the process of uh, 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 abolishing entail estates into what we call fee simple through the process of common recovery. Okay, so it says when dealing with the ownership of real estate, a purchaser or lender requires satisfactory proof that the seller is the owner and has a good title to the property. This documentary proof is called evidence of title. There are four generally used terms for title evidence: abstract title, which the attorney gives you, and then the deed that you receive from the attorney is insured by a title insurance company. Then you have torrent certificate, which is then grants certificate of title. So all these are certificate instruments of conveyance, But once again, it clearly said a deed is not proof of a title. It proves the grantor transferred the property, but does not prove the grantor had a clear title. That's what the next page is going to say. All right. This is parcel estates, pretty much lot and block numbers. Okay. This is pretty much what you subject to today. It says here, estates and interest. No equitable interest, just the interest. All right. A non-possessory use. All right. An interest in it, not an equitable interest in it. Estates and land. Not all forms of ownership of real estate are equal. An owner may or may not be able to pass property on to heirs. Sometimes ownership may exist only as long as property is used for a specific purpose. In addition, other persons may possess certain interests, legal claims, or rights in one's real estate. The amount and kind of ownership interest that a person has in real property is an estate in land. So all y'all talking about allodial land, you'll know what you're talking about. All right? Because the only person that has the right to allodial is the crown. Estates and lands are divided into two major classifications: freehold estates, less than freehold, or lease estates. Okay? Which can be broken down even further. Freehold estates are estates of independent length. A person may own the estate for a I forgot. I don't see that word. Three different types are called fee simple, fee determinable, and fee in life estates. Okay, that's the three types. All right. Once again, fee simple. Estate fee simple is the highest type of interest in real estate recognized in American law. See, they left that out. They want to make you see that is the highest, but it's not the highest. A fee simple estate is one in which the holder is entitled to all rights and property. There is no time limit on fee simple estate, but it's subject to reversion and remandment. Yeah, so there is a time limit. On the owner's death, the estate passes to his or her heirs. Okay, that's not fee simple. The only way it passes to his or her heirs is by a testamentary will. Okay, being determinable. In New Jersey, fee determinable, also known as conditional fee or defeasible, is an estate in land and can terminate on the occurrence of a non-occurrence of a specific event, such as a lien, okay, a lis pendens. It didn't say indefeasible, it says defeasible, conditional. and the other is life estates. And life estate is limited to the life of a specific person. The owner of a normal life estate does not have the right to pass ownership to an heir because the life estate ends with the death of the owner. For example, blase, blase, blase. If Alan maintains reversionary interest, the property will revert back to Alan. Understand? Go look at fee and simple. No, look at acquisition of sovereignty, and then get into what we call reversionary interest. Okay, so let's move forward. So we can move out of here. Contract. Contract clause, Article 1, Section 10. All right, that's the original contracting clause between creditor and debtor. We know the creditor was the crown and the debtors were the colonies. All right, the parts of. Y'all better listen to what's being said to y'all. The original contract forbids the appearing of the obligation of a contract. The framers of the Constitution added this clause in response to the fear that the states would continue a practice that had been widespread under the Articles of Confederation, that of granting private relief. This is the bankruptcy clause, y'all. All right? Granting private relief. Legislators will pass bills relieving particular persons, particularly influential persons, of their obligation to pay their debts. It was this phenomenon that also prompted the framers to make the bankruptcy law, the promise of the federal government. Did you hear that? Okay, so that's the reason why bankruptcy laws were created. All right, to relieve those who were debtors, and when they went into when they were subject to pay their debts to their creditors, they filed bankruptcy. All right. It says during and after the revolution, many states enacted laws favoring colonial debtors to the detriment of foreign creditors. They're talking about the crown. Federalists, especially Alexander, believed that such a practice would jeopardize the future flow of foreign capital into the fledgling United States. Consequently, the contract clause, by ensuring the inviolability of sales of financing contracts, encouraged an inflow of foreign capital by reducing the risk of loss to foreign merchants trading with their investing in the former colony. Now, we know that the United States didn't have the ability to do interstate commerce. They only had domestic commerce amongst the colonies. So when you're dealing with raising revenue, this was called free and common focus. On an international level, that involved the crown, okay? Because the crown was the original creditor. How we know that? Because it was the crown who was ruling under the Articles of Confederation, as we know, it's called the Province of New Jersey. These are receipts. The New Jersey Provincial Council was the upper house of the New Jersey Legislature under the colonial rule until it was replaced with the New Jersey Legislative Council under New Jersey's Constitution of 1776. The authority of the New Jersey Provincial Council was the crown. Did everybody see that? I'm tired of going over this. It was the crown. The Provincial Council was established in 1702 when the profiteers George Coretta and John Berkeley surrendered their deeds, their land tenures, back to the crown. So that means that they were discharged of their tenure. And governed United Two Colonies as the province of New Jersey as a royal colony, established a new government as established by the royal governor, Viscount Cornbury. Okay? These are straight, undiluted facts. And under Viscount Cornbury, the royal governor, a lawyer from the Middle Temple, outlined the government or body of politics as a fusion of power, which allowed for an overlapping of the executive, legislative, and judicial authority, and provided for a bicameral legislature consisting of the council and the General Assembly. All right? We must understand that. On December 6, 1775, Governor William Franklin paroled New Jersey legislator until January the 3rd, 1776, but it never met again. Why? Because on May 30th, 1776, William Patterson, Franklin attempted to convene the legislature, but was met instead with the order from the Jersey Provincial Council for his arrest. The Provincial Congress approved a new constitution on August 13th. A new legislature was elected, with the appointed provincial council being selected by the elected New Jersey Legislative Council. Okay? We must understand these facts. Don't forget these facts. Rely on these facts to come to your conclusion of where you at as a creditor and debtor. Why? Because we know that the United States, also known as the Articles of Confederation, was subject to what we call the Crown Debt Act of 1541. The Crown Debt Act, passed by Henry VIII, was an act of Parliament of England. You see our seal here. The belt is no longer can be taken off. It's uniform. It's perpetual now. It's back in the hands of the true king. All right, the true owner by what we call primogeniture, by birthright. Okay, that's how it was supposed to pass in the first place. 1 second. Crown Debt Act. The Crown Debt Act of 1541 was an act of Parliament of England which introduced the concept of crown debt. In English law, i.e., that the crown has priority for its debts before all other creditors. Okay? All other creditors, the crown get paid first. Even bankruptcy can't stop the crown from getting paid. Let's see. Just reiteration. By various statutes, the first Crown Debt Act of 1541 dated from the reign of Henry VIII of England. The crown had propriety for its debts before all other creditors. At common law, the crown always had a lien on the land and goods of debtors by record, which could be enforced even when they had passed to the hands of other persons, i.e., a third party, i.e., or custodial legis, i.e., under the custody of the law, which you are all under now. You are all under the custody of the law as debtors. You've been pledged as property. All right? You've been pledged as property as a result of interstate. Right? Interstate meaning that there are no more heirs. So everything is sheets back to who? The crown. It's a debt to the crown. All right, let me just show you the diagram. They ain't hiding this from you. Right here. This is a real estate book, y'all. Person dies interstate, no heirs, it is streets. It goes back to who? The custodial legis, under what we call bona vacatina, abandoned property. Who has it? Who? The state of New Jersey, which is nothing more than a corporation. Okay? A corporation. You see what it says? Property taken by. Action, process, property taken by who? The state of New Jersey. It's not their property. Okay? No, it never was their property. Let's prove it. Contract clause. Just to read the full text. This is for an English person's perspective. I can't speak for anybody else. This is how you should be understanding it as an English person. If you got English surname, this is what you should understand in lieu of what they call the English contract law. Because let's go to English contract law first. Since we're English, right? That would be the right thing to do. English contract law is the body of law that regulates legal binding agreements in England and Wales, with its roots in lex mercatoria and the activism of the judiciary during the Industrial Revolution. It shares a heritage with the countries across the Commonwealth, such as Australia, Canada, India. For membership of the European Union, continued membership and UNIDROIT, and to the lesser extent, the United States. An agreement that is enforceable in the court is a contract. Everybody understand that? But with the contract from an English perspective, it's different from anybody else's perspective if you're not English. All right? Very different. All right? Right here. Terms in agreement are incorporated through express promises by reference to other terms, potentially through a course of dealing between two parties. Those terms are interpreted by the court to seek out the true intentions of the parties from the perspective of the objective observer in the context of their bargaining environment. Where there is a gap, courts typically apply terms to fill the spaces. But also through the 20th century, both the judiciary and legislature have been intervened more and more to strike out surprising and unfair terms, particularly in the favor of consumers, employers of tenants with weakening or weaker or unequal, unequitable bargaining power. Okay? Very important. If that is the case, then it results in an unconscionable agreement. Okay? For English people. I can't speak for nobody else. An unconscionable agreement can be escaped where a person was under duress and undue influence. Undue influence causes duress. Undue influence is a psychological control of a person's mentality based off their reasoning of the contract which is in question, based off their understanding of the questions when the contract took form. Okay? For English people, the contracts that we are now subject to, driving license, insurance card, rent payments, whatever they may be, are unconscionable to you. All right? This was not your position before the contracts created by the states or United States were created, because everything you get is on the receiving end. All right? They're the lender, you're the borrower. They're the creditors, you're the debtor. Okay? I showed you the list. All right? So unconscionable agreement can be escaped where a person under duress or undue influence, or they're voluntarily was being exploited when they ostensibly agreed to a deal. Children, mentally incapacitated people, and companies whose representatives are acting wholly outside of their authority are protected against having agreements enforced against them where they lack the real capacity to make a decision to enter into an agreement. Did you hear that? Some transactions are considered illegal and not enforced by courts because of the statute or a ground of public policy. In theory, English law attempts to adhere to the principle that people should not only be bound when they have given their informed, should only be bound when they have given their informed and true consent to a contract. Okay? Very, 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 very important. So if you're not consented to the contract based off your conscientiousness, and conscientious means to be conscionable. To be unconscious is to be unconscionable, which brings both unconscionable terms and conditions. All right, somebody gonna benefit off somebody else, such as the cartoon I showed you in the analysis of the cartoon when we first started this lecture. Okay, so let's look up not just the definition of conscionable agreement under English law, because we just did. All right, matter of fact, let's do that. Okay, let's just do that. Unconscionability in English law is a field of a contract law and a law of trust, all right, which prohibits the enforcement of a voluntary or consensual obligation, unfairly exploiting the unequal power of the consenting parties. Inequality of a bargaining power, i.e., weaker bargaining power. We are creditors. We don't have a weakening bargaining power. We have gold and silver. If there are no gold and silver, then what? If all debt must be discharged. That was Article 1, Section 10 says. Okay? And another term used to express essentially the same idea for the same area of the law, which can in turn be further broken down into cases such as one of duress and undue influence. The latter has more of an effect, which results in the first one, the former. What is undue influence? Because you can't turn your head on this. These are straight facts. I'm actually being your doctor today. All right? I'm speaking as your doctor today, your psychologist. Because the majority of y'all is crazy. Undue influence is a psychological process by which person's free will and judgment is supplanted by another. It is a legal term and the strict definition varies by jurisdiction. Generally speaking, it means by which a person gains control over their victims' decision-making through manipulation tactics and unfair pressure, typically for financial gain. Historically, UI or undue influence has been poorly understood even in some legal circles, okay? Very important to understand that. This is the reason why I'm telling you that when you're brought in a commercial setting, in regards to you being an English person, you need to raise the question of the contract being unconscionable. They got statutes for that, okay? They got it on the federal level and the state level, okay? Let's see. New Jersey revised statute, because we're talking about New Jersey. You want to go to the federal, just look up United States Code 2-301, okay? Majority of the states' unconscionable contract clause for the state has the latter part of in their statute 2-302, all right, universal, all right? So it says commercial transactions, unconscionable contracts or clauses in that contract. One, if the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time. Only make a reference to English people in reference to English contract law, right? That's the only thing I'm talking about. Everybody else, you have to interpret this in a different manner. But for English people, if the court as a matter of law finds the contract of any clause of a contract to have been unconscionable at the time it was made, the court may refuse to enforce that contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. You hear that? Two, when it's a claim or appear to the court, any court on the federal state level, that the contract or of any clause thereof may be unconscionable, the party shall be afforded, key word, afforded a reasonable opportunity to present evidence as to the commercial setting. Hear that? The commercial setting. Commercial setting deals with commerce between two parties, which automatically involves contract law. And you must go back to the original contracting clause. All right? Or else it's unconscionable and it causes duress by undue influence. We already defined what that is. That means you ain't thinking for yourself. When it's a claim or appears to the court that the contract or any clause thereof may be unconscionable, the parties should be afforded a reasonable opportunity to present evidence as to the commercial setting, purpose, and effect to aid the court in making the determination. Because they're about their business all day long. Their business is unconscionableness. All right? So if you're going to go on there unconscionable, hell, you fit in the script. All right? You agree to be a party to the contract. It's already determined when they run your name. Yeah, license registration. I don't know what you're talking about, license registration. I don't have any contract with you. I'm a subject of the crown. If I owe any debt, if you cannot be a debtor, because all these contractor notes to me being in the position of a debtor, it's going to be the crown that get paid. Because yes, in that sense, or in that term, yes, I'm a debtor to the crown. All right? We just read it, Crown Act of 1541. He or she get first dibs in all debt from the creditor. Okay? You must know this. All right, let's go. Let's prove it. Marshall versus New York, 1920 case. I already talked about this. It was in my last lecture. I might not have broken it down as much as I'm doing now, but I didn't mention this case, so there's nothing new. Marshall versus New York. What platform delivers like I do? At common law, the Crown of Great Britain. This is New York. I'm in New Jersey. That's a state over. All right. At the common law, the Crown of Great Britain, by virtue of a prerogative right, has priority over all subjects for payment out of a debtor, property of all debts due to it, whether the property was in possession of the debtor or a third person or a custodial legis, and the priority could be defeated or postponed only through passing the title of such property, absolutely or by way of a lien, before the sovereign sought to enforce his right. But no sovereign there to enforce their right. But no monarch there to be representing the crown as the public trust for the public trust, because it all involves trust law. Okay. 2. A like priority has presumed by all the states in the Union, now called the United States of America, then called the Articles of Confederation, based off their acquisition of sovereignty, based off their assumed prerogative, which was only created through statute. Okay? A like right priority based on the sovereign prerogative as was established by the Crown belongs to the state of New York, as her highest court has decided through her adoption by her constitution of the common law, and attaches to a debt due the state by a sister state corporation as a license fee or tax for the purposes of doing business in New York. So all you citizens of New York and all you citizens of the states, of all the states back called colony, that's why you're called debtors. Okay? You're not a creditor, you can never be a creditor. The crown is the first creditor, and the crowns get first dibs of all his subjects' debt. And I'm the king, I ain't gonna charge you no debt. You know what I'm saying? You good. You can discharge your debt because you never had a debt in the first place based off the original contract clause, which says that the only thing that you repay a debt is gold and silver. All right? But I'm only speaking for the English. All right? So the question that the courts are now asking themselves, based off the complaints that I filed against the state of New Jersey, the United States Department of Treasury, the federal government, etc. All right? The question of law you should be asking yourself, and in lieu of your legal standing, either as a debtor or creditor, whether this priority is a prerogative right or a rule of administration, which is the question of local law, the determination which by the higher courts of the state concludes the federal courts. All right? That's what you should be asking yourself. This is what you should be using as the measuring rod to your standing in law, not some YouTube channel talking about we come from Africa or we this and we that, what's going on dealing with the Pride March, or what's going on dealing with the the migrants kicking. All that's going to continue to happen. All right, it's going to continue to happen. And why you're viewing this happen because you're not taking your proper place. All right, we are at the English nation. The king is saying to it. All right, I'm saying to that our estate is returned to us. All right, let's prove it. Now it says, back to Marshall, we're talking about the king's prerogative. Everybody read that first paragraph real good. Read this first paragraph here before we go any further. Parts of not that part. Part 1. I need y'all to understand that right there. Part 1. Read that in and out till I get back. At common law, the Crown of Great Britain, by virtue of the prerogative right, has priority over all subjects for the payment out of the debtor's property of all debts due to it, whether the property was in possession of a debtor, of a third person, or custodial legis, and the priority only could be defeated if there was a lien put on it. And right now, there's a lien put on you by the states in the United States, right? Because if you owe a debt, then a lien is put on you. All right? Very important for you to understand that. And we're talking about, we already read the Crown Act of 1541. Crown Act of 1541 by Henry VIII from the House of Tutors of the Lancaster branch, a cadet branch for the Plantagenet Crown, clearly says that the Crown gets first dibs in all debts. Okay? Now we got a case law, Marshall versus New York, saying this. Okay? Let's go to Chisholm versus Georgia. This is dealing with a petitioner right to bring an action of assumption or a tort against the United States officer or agent. All right? The United States can't claim sovereignty, the states claim sovereignty unless they waive them, but you can bring a claim against an officer for a tort. All right? Okay, we're talking about debts, right? This is Chisholm versus Georgia. It says here, now let us consider the case of a debt due from a state. None can I apprehend be directly claimed, but in the following instances. First, in cases of a contract with the legislature itself. Two, in the case of a contract with the executive or any person or any other person in consequence of an express authority from the legislature. Third, Article 3, Section 1, Article 3, Section 2, y'all, they can be sued. Third, in the case of contract with the executive without any special authority. In the first and the second case, the contract is evidently made on a public faith alone. Every man must know that no suit can lie against a legislative body. His only dependence, therefore, can be the legislator on principle of public duty, will make a provision for the execution of their own contract, and if that fails, wherever reproach the legislator may incur, the case is certainly without remedy in any of the courts of the state. I better listen. It never was pretended, even in the case of the Crown in England, that if any contract was made with Parliament or with the Crown by virtue of an authority from Parliament, that a petition to the Crown would in such case lie. In the third case, a contract with the governor or a state without any special authority. This case is entirely different from such a contract made with the Crown of England. The Crown there has a very high prerogative. In many instances, it's a kind of trustee for a public interest. In all cases, represents the sovereignty of the kingdom. It is the only authority which can sue or be sued in any manner on behalf of the kingdom in any court of justice. A governor of a state is a mere executive officer. His general authority very narrowly limited by the constitution of the state with no undefined or disputable prerogatives, without power to affect 1 shilling of the public money, but as he is authorized under the Constitution or by a particular law. Having no color on himself, having no color to represent the sovereignty of the state, so as to bind it in any manner to its prejudice, unless special authorized to. And therefore, all who contract with them do it at their own peril and are bound to see or take the consequence of their own indiscretion. Come on, Cliff. Okay. Got a heavy trigger. And their own discretion, that he is strict authority for any contract he makes. Once again, and therefore all who contract with him do it at their own peril and are bound to see or take the consequence of their own indiscretion. That he has strict authority for any contract he makes. Of course, such contract, when so authorized, will come within the description I mentioned of cases where public faith alone is of grounds of relief, and the legislative body the only ones that can afford a remedy, which from the very nature of it must be the effect of its discretion, not of any compulsory process. If, however, any such case were similar to those which would entitle a party to relief by petition to the King of England, the petition be only presentable to him, as he is the sovereign of the kingdom, so far as analogy is to take place. Such petition in a state could only be presented to the sovereign power, which surely the governor is not. Chisholm versus Georgia. All right? We must understand that. So all the king's prerogatives is part of his jury gallery. Okay? We know the king is a corporation soul. Okay? The crown is a corporation soul. The English throne is a corporation soul because of the personification of the crown by the king by way of being a natural person. Okay? That's called the king's two bodies. All right? The king's two bodies. We're going to talk about that in a second. If I pay attention. And there are, in my opinion, the most essential differences between the old cases of corporations to which the law intimated has reference, and the great and extraordinary case of the state separately possessing as to everything simple related to themselves, the fullest power of sovereignty, and yet in some other defined particulars, subject to a superior power composed out of themselves for the common welfare of the whole. The only law concerning corporations to which I can see the least reference is to be had is the common law of England on that subject. I need not repeat the observation I made in respect to the operation of that law in this country. The word corporation is, in the larger sense, has more extensive meaning than people generally are aware of. Are y'all listening? Are y'all listening? Anybody in politics, did y'all hear that? Special reference to that part right there. Anybody in politics, sole or aggregate, whether its power be restricted or transcended, is in the sense a corporation. The king, accordingly, in England is called a corporation. Now they associate the king in England with the body politics, a corporation soul, which is a natural person, okay? The king, according in England, is called a corporation. I have therefore, in contradiction to this large and indefinite term, used the term subordinate corporations, meaning to refer to, I think I missed something. So the king, according in England, is called a corporation. So also by the very respectable author, the parliament itself. In this extensive sense, not only each state singly, but even the United States may, without impropriety, be termed a corporation. I have therefore, in contradiction to this large indefinite term, used the term subordinate corporations, meaning to refer to such only as only capable of the slightest application for the purpose of the objection, whose creation and whose powers are limited by statute. That's their prerogatives, and their priority come from, as we see in United States versus Lee. All right. Was that United States versus Lee? Marshall versus New York. No, Marshall versus New York. All right. The difference between such corporations in the several states in the Union are related to the general government are very obvious in the following particulars. First, a corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. It owes its existence, its name, in its laws, except such laws that are necessarily laws as are necessarily incident to all corporations merely as such, to the authority which created it. A state does not owe its origin to the government of the United States. It is the highest or in any of its branches. It was in existence before it. It derived its authority from the same pure and sacred source as itself, the voluntary and deliberate choices of the people. 2, corporations can do no act but what is subject to the revision either of a court of justice or some other authority within that government. A state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority unless its special instance where the general government has power derived from the Constitution itself. A corporation is altogether dependent on that government to which it owes its existence. Its charter may be forfeited by abuse. Its authority may be annihilated without abuse by an act of the legislative body. A state, though subject in certain specified particulars to the authority of the government of the United States, is in its other respect totally independent upon it. The people of the state created it. The people of the state can only change its constitution. Upon this power, there is no other limitation but that imposed by the Constitution of the United States. Did y'all hear that? That's the Chisholm versus Jordan. Okay, so we know the difference between the corporation soul and the corporation aggregate. We know the king represents the corporation soul. He's the creator of all corporations, and there were the corporations that he's created were governed by parliament, called king and parliament, i.e., under their own body of politics, just that of the crown, as we see under the New Jersey Provincial Council. Okay, which is perpetual. The crown is perpetual. All right. Body of politics, because it said any body politic, sole or aggregate, whether its power be restricted or transcended, and is in a sense a corporation. The king, accordingly, in England, is called a corporation. Let's look up body of politics. Everybody pull it up. The body politic is a polity such as the city, realm, or state, considered metaphorically as a physical body. The story of the sovereign is typically portrayed as a body head, and the analogy may also be extended to other anatomical parts, as a political reading as Aesop's fable, the belly and the members. The image originates in the ancient Greek philosophy. We're not Greek, so we're not going to go with that interpretation. Let's move forward. We're going to go right here. In Latin Europe, the body politic took on a jurisprudential significance, okay? And this deals with law. So that's most significance to us as English people, because our source is the law, not no belief, not no abstract story, not some fable, not some myth, not some folklore. We use law going back to time immemorial, time out of mind. This goes back to time out of mind, okay? It says, The body politic on the jurisprudential significance by being identified with the legal theory of the corporation, gaining salience in the political thought from the 13th century on. In English law, the image of the body politic developed into the theory of the king's two bodies, the crown as corporation soul. Okay? So let's deal with the abstract first. Since I say I'm King of the Peaceful, and he's our Jesus Christ, which I'm the reincarnation of. So we all are us synonymously make up the mystical body of Christ through the reincarnation or the personification or the personification, incarnation, or the incorporation of the mystical bodies or the mystical sources or the mystical ideas that went into those stories and bring them to a concrete a concrete understanding or overstanding so that you can make parallel use of those in this day and time. The term body politic derived from the medieval Latin corpus politicum, politicium. I'm saying it wrong, for forgive me, which itself developed from corpus mysticism, originally designating the Catholic Church as the mystical body of Christ, but extends to the politics from the 11th century on in the form of corpus republicae, mystical body of the commonwealth. Okay? Just going to touch on this for a few. King's Body Politics. I got this book as well on download. Everybody look it up by Ernest Kantorowicz. Good book. All right. In Tudor and Stuart England, the concept of the body politic was given a particular additional significance to the idea of the king's two bodies, which is seen this expressed in case law. Okay? We've seen this expressed in actual case law about the king's two bodies. All right? And we've seen the crown, which is the corporation soul, which represents the king's two bodies, personified in the Crown Act of 1541 by who? King Henry VIII from the House of Tudors. All right, legislation from his time. All right, in Tudors and the Stuart England, the concept of the body top politic was given a peculiar additional significance to the idea of the king's two bodies. The doctrine discussed by the German American medievalist Ernest Kantorowicz in his eponymous work, the legal doctrine held that the monarch had two bodies, the physical, king body natural, and the immortal, king body politic. Upon the demise of an individual king, his body natural fell away, but the body politics lived on. This was indigenous development of English law without a precise equivalent in the rest of Europe. You don't believe him? You can go check out what's his name? Blackstone. Okay, he says the same thing in this commentary. Extending the identification of the body politic as a corporation, English jurists argued that the Crown of England was a corporation soul, a corporation made up of one body politic that was at the same time the body of the realm. It is parliamentary estate. It also the body of the royal dignity itself, the two concepts of body politic that were conflated, infused together. Okay? Infused together. We see that in the New Jersey Revised Statutes as well. Certain tenures and holdings turn into free and common tokens. The tenures of honors, manors, lands, and tenements of hereditaments or of estates of inheritance as the common law held either of the King of England or of any other person or body politics or corporate at corporate. You hear it right there. I don't want to read the rest of it because I got a point to make in regards to uh, uh, New Jersey. All right, New Jersey has clipped our birthright. Okay, they clipped our birthright. All right, I'm going to prove it with these statutes. Okay, so as we can see, King of England or other person body politics. So that means that when there's a demise, that means that one king is transferring and another king coming to the position. Okay, by primogeniture. All right, let's see. Let's move forward. Okay, so with that in mind, we know that under what's the case? United States versus Lee, we know that the what's that? United States versus Lee, the Crown has first priorities in all debts of its subject. Okay, all debts of the subject. Is that this case or was it another case? I definitely want to lose that point. Let me just find it real quick, everybody. It's Ch.D. versus Georgia. Marshall. Where is it at? Come on. Bear with me, y'all. Just find Marshall. Oh, I'm sorry, y'all. I knew what it was. Marshall versus New York. Common law of the Crown of Great Britain, by virtue of the prerogative right, has priority over all subjects for the payment of the debts, property of all debts due to it, whether the property was in the possession of the debtor or a third person or custodial legis. Okay, let me go back here. Make sure. let's move forward. All right, so we got the body politics down. We know the king's true body. All right, so it's very important to understand this because a lot of us misunderstand our rights as English people, which brings me here to this case law. Okay, this is page 38. Twinning versus state. Page 38. All right, twinning versus state. This is case law. Let's say 20 or 38. Yeah. Page 38, okay? Everybody listen. What, let me inquire, must then have been regarded as principles that were fundamental in the liberty of the citizen. Every student of English history will agree that long ago, before the adoption of the Constitution of the United States, certain principles affected the life and liberty of the subjects had become firmly established in the jurisprudence of England, all right, and were deemed vital to the safety of freemen, and that among those principles was the one that no person accused of a crime could be compelled to be a witness against himself. This is the reason why contract clause is very important, and understanding what's unconscionable about those contract clauses, because when they haul you into court, that means that if you participate in those proceedings, then you're giving testimony, all right? That's a violation of the Fifth Amendment, all right? But there is no Fifth Amendment protection under the 14th Amendment, whether you know it or not, okay? Look it up, all right? It says, let me go back here. England, and were deemed vital to the safety of a freeman, and that among those principles was that one principle was the one that no person accused of crime could be compelled to be a witness against himself. It is true that at one time in England, the practice of questioning the prisoner was enforced in the Star Chamber proceeding, okay? And the Star Chamber proceeding. But we have the authority of Sir James Fitzjames Stephan in his history of criminal law of England for saying that soon after the Revolution of 1688, the practice of questioning the prisoner died out. The liberties of the English people had been placed firm on a foundation. Personal liberty was thenceforth jealously guarded. Certain is that when the present government of the United States was established, it was the belief of all liberty-loving men in America that the real, genuine freedom could not exist in any country that recognized the power of government to compel a person accused of a crime to be a witness against themselves. Okay, that was done in what we call the Star Chamber. Anybody ever heard of the Star Chamber? Never heard of it? Let's just get another review on it. Right, another source. When we go to Wikipedia, there's another source, another case law. All right. Page 7. This is Pulliam versus Allen, 1984. Pulliam versus Allen, 1984 case, United States Supreme Court. A writ of circulatory of United States Courts of Appeals for the Fourth Circuit. Okay? For the Fourth Circuit. Sorry. At the common law itself, there is no such thing as an injunction against a judge. Injunction relief was an equitable remedy that could be awarded by the chancellor, i.e. the king's secretary, only against the parties to proceedings before the court. This limitation on use of the injunction, however, says nothing about the scope of judicial immunity. as the limitations derive not from judicial immunity, but from the substantial confines of the chancellor's authority. Although there was no injunction against common law judges, there is a common law parallel to that Title 42 of the United States Code, Section 1983 injunction at issue here, which means deprivation of rights. All right, that parallel is found in the collateral perspective relief available against judges through the use of the king's prerogative writ. Okay, so when you file a writ as a petition of right, as stated in Ch.D. versus Georgia, we know in Ch.D. versus Georgia, they also recognize the difference between the corporation sole and the corporation aggregate, and being the king being the one to grant the deeds or the charters for corporations to exist, and as it gave it life, it can take its life away. Under Title 42 United States Code, Section 1983, dealing with deprivation of civil rights, we know civil rights is not those rights guaranteed by the 14th Amendment, but those rights guaranteed by the common law of England, set forth in the Magna Carta. The parallel is found in the collateral perspective relief available against judges through the use of the king's prerogative writ. Okay? Through the king's prerogative writ. That's very important. The crown's writ is the prerogative writ of the monarch. The crown's writ of the monarch's writ is a prerogative writ of the king, i.e., that of the corporation sole. A brief excursion into common law history helps to explain the relevance of these writs to the question whether the principles of the common law immunity bar injunctive relief against a judicial officer. The doctrine of judicial immunity and the limitation of prospective collateral relief, which we are concerned, have related stories. Both can be traced back to the successful efforts of the King's Bench to ensure the supremacy of the common law courts over their 17th, 18th century rival. Okay, so the King's Bench had rivals. Did you hear that, y'all? Yes, the King's Bench had rivals. We know the King's Bench was invested in New Jersey Supreme Court, right? That was Villain versus Harris says, all right? Villain versus Harris says that. Let's just see that. This is how we be arguing that in those courts of law. This is how I'm going to do it. How is your leaders able to do this? All right. It says here, New Jersey's first constitution, July 2nd, 1776. That's their second birth certificate. They had two birth certificates. The charter granted by Charles, the Duke of York, and then the July 2nd, 1776, which were both terminated. All right. They were both terminated, and they still are doing business unlawfully under these unconscionable contracts. I'm going to prove it. New Jersey's first constitution adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. That violated the contract clause because why? They did not want to pay their debt. Article 22 of the Constitution continued the common law of England in force. That constitution was replaced by the Constitution of 1844. Mildly largely instructed of the content of the Constitution of the United States, Article 10, Paragraph 1, it too continues the force of the common law, as well as the existing courts of law and equity. So also the current Constitution of 1947, by Article 11, Section 1, part of Paragraph 3, continue to enforce all existing laws of the King's Bench. How we know it, it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which the legislature was powerless to cut down or to assign to other courts. This principle was especially stronger in the field of prerogative writs, of which writ of circulator, or what they call now a petition to certification, was one of the most frequently sought. The complexities and technicalities involved in these prerogative writs, including the writ of circulator, induced the draftsmen, i.e. the judges of the 1947 Constitution under, what's his name, Alfred Driscoll, to erase the procedural necessities while assuming to preserve the judicial authority and the remedies. This was achieved by single sentences. They now took the legislative power that was given to the Supreme Court to be the head of the King's Bench, the King's Bench, Supreme Court of New Jersey, and now gave it to the Superior Court of New Jersey. This was a violation of the contract clause. I brought this up many times. Y'all fail to realize this, but they're in trouble for that. Why? Because they all are unconscionable contracts. Let's prove it. Let's go back here. It says, a number of courts challenged the King's Bench of New Jersey. All right, we just seen it. Because of the technicalities and the complexities of the prerogative risk, they separated it. All right, they separated it. We must understand that. A number of courts challenged the King's Bench for authority in those days. Among these were the councils, the Star Chambers, the Chancery, the Admiralty, and the Ecclesiastical Court, in an effort to assert the supremacy of the common law courts. Lord Coke forbade the interference by the courts of equity with matters properly triable by the common law. Coke and his colleagues of the Star Chamber had declared the judges of the King's Bench immune from prosecution and competing courts for their judicial acts. In doing so, they announced the theory upon which the concept of judicial immunity was built. Let's go down here. The judges involved declared the judges of the King's Bench immune from prosecuting and competing courts for their judicial acts. In doing so, they announced the theory upon which the concept of judicial immunity was built. The judges involved in Banker and Barker was a common law judge of Assize, which had presided over a murder trial. He was then charged in the Star Chamber with conspiracy. The court concluded that the judge of the common law should not be called to account before any other judge at the suit of the king. Did you hear that? And it was agreed that in so much as the judges of the realm have the administration of the justice under the king to all subjects, they are not to be drawn into question for any supposed corruption, which extends to the annihilating of the record or of any judicial proceedings before them, or tending to the slander of the justice of the king, which it will trench to the scandal of the king himself, except it be before the king himself. For they are only to make an account of God and the king, and not to answer to any suggestion of the Star Chamber. Okay? So they are the answer to the king and the King's Bench as they account to God, and not that of the Star Chamber. Okay? So let's visit the King's Bench for a second, and let's visit the Star Chamber. Because we know the King's Bench is composed of the Courts of Common Pleas and the Courts of Exchequer, which is courts of what we call Chancery. Okay? Then we have that of what we call that of the Star Chamber. So let's just loosely visit this, because you can look at it on your own time. Courts of the King's Bench, which we know, as we just read in case law, Bell versus Harris, is in New Jersey, because New Jersey was the crown. Okay? It was the crown. And the common law of England and the King's Bench of England, or the crown under the king, was here established in Bell versus Harris from 1776 all the way to 1947. Okay? Had always been there. The Court of the King's Bench, formerly known as the Court of the King before the King himself, was the court of common law in the English legal system. Created in the late 12th and early 13th century from the Caribbean regions, the King's Bench initially followed the monarch on this child. This is called an itinerant court. The King's Bench finally joined the Courts of Common Pleas and Exchequer Pleas in Westminster Hall in 1318, making its last travel in 1421. The King's Bench was then merged to the High Court of Justice by Supreme Court of the Judiciary Act of 1873. All right? Everybody understand that? There's too much information there. This is revealed Star Chamber. Show you the difference between the two. All right, so we visited the King's Bench, King and Council. It goes back to the 12th century. But then when you get into the Star Chamber, we come up under that which was formed under the Star Chamber Act by King Henry VIII. All right, here King Henry VII. Okay, under the being that he was of the cadet branch of the Lancaster branch, which he then created the House of Tudors, which Henry VIII sent out from. So Henry VII created the Tudor branch, which was the cadet branch of the Lancaster branch, which was the cadet branch of the Plantagenet crown, which my family just sit down from Goblet the Fifth County Jew, son of folk. Okay, so the court evolved. Let me just quote. Attorney William Blackstone, a notable English jurist, writing in 1769, speculated that the name had been derived from the legal word star, meaning the contract or obligation to a Jew, from the Hebrew word shtar, meaning document, pardon from pronouncing wrong. This term was used until 1290, when Edward I of the Plantagenet crown, son of Henry III, had all Jews expelled from England. Blackstone thought the Star Chamber might originally have been used for the disposition and storage of such contracts. However, the Oxford English Dictionary gives this etymology no claim of consideration. The courts evolved from the meeting of the King's Council, Quaere Regis, with its roots going back to the medieval period. The so-called Star Chamber Act of King Henry VIII's Second Parliament of 1487, under the Supremacy Act, did not actually empower the Star Chamber, but rather created a separate tribunal distinct from the King's General Council. Did you hear that? Here you see our family crest. All right. It said it did not actually empower the Star Chamber, but rather created a separate tribunal distinct from the King's General Council. Okay. Yes, all these judges are lawyers and attorneys. All your judges. They're learned in the letter of the law. Okay? So without too much focus on that, let's move forward. We're talking about the King's prerogative. Okay? We're talking about the King's prerogative. Very important. All right? Because the King's prerogative comes from under the authority of the Crown. Okay? And under the Crown, it's the creditor. Okay? The Crown is the creditor. We already validated this. Okay? Let's go to the United States versus Britain. It is hardly essential to define prerogative with technical accuracy. Under Mr. Blackstone's definition, it can only be applied to those rights and capacities which the king enjoys alone, in contradiction to others, and not to those which he enjoys in common with any of his subjects. Okay? Blackstone's commentary, a New Jersey chancellor had defined royal prerogative. New Jersey chancellor, i.e., the king's secretary, i.e., defines royal prerogative as the special privileges which a sovereign has over all persons and out of the course of the common law, by right of the regal dignity, i.e., his jury gallery. In Great Britain, the royal prerogative includes the right of sending and receiving ambassadors. Now this power has been given to the president, okay, or the Secretary of State, okay, which is part of his cabinet. In Great Britain, the royal prerogatives included the right of sending and receiving ambassadors, of making treaties, and theoretically of making war and concluding peace, of summoning parliament, and of refusing assent to a bill, with many other political, judicial, ecclesiastical, etc. privileges. 6th century dictionary prerogative. The word simply means a power which is discretionary and above and uncontrolled by any other will. It is frequently used to express the uncontrolled will of a sovereign power in the state. It is applied not only to the king, but also to the legislative and judicial branches of the government. The king power or authority or privilege whatsoever is scope or whatsoever attribute there is in the sovereignty rests with the people in this country. When you gave it to the people of this country, i.e. the colony, not the English people, because the English people, the English subjects recognize that power of the sovereign. All right? Don't try to flip that. You can't have a bunch of sovereigns running around. Okay? Now you have a power struggle. Okay? We understand the importance of the queen bee. All right, we understand the purpose of the purpose of what she mean to the high. Okay, all right, but we understand the purpose of the king as well. All right, because the king has been taken out of his jury gallery as a result of the devising of the estate, which is not prohibited in England to that being of the estate being divided by a woman. We already proved that and laid the case law, not disqualifying the woman because I have a queen. Okay, let's move forward. The Supreme Court declared that the right and prerogative of payment of debts due to the government is the prerogative of the crown. Well known to the common law is right here in your face. Okay? It's right here in your face. It is founded not so much upon personal advantage to the sovereign as above motives of public policy in order to secure an adequate revenue to sustain the public burden and discharge the public debt. The claim of the United States, however, does not stand upon any sovereign prerogative, but it is exclusively founded upon the actual provisions of their own statutes. The same policy which governs in the case of the royal prerogatives may be clearly traced in these statutes, and that policy has mainly a reference to the public good. There is no reason to give them any strict and narrow interpretation. You don't like that? Go see United States versus State of Bank of North Carolina, and they tell you the same thing. All right. Let me go to my point here. So we understand the king's prerogative, right? The power of the king, the power of the crown, right? The power of the English crown, I should say. Oh, I'm on the wrong case. It's just United States versus United States versus Lynn. We're talking about the king's prerogative. Everybody see this? United States versus Lynn. In all cases where the title to property came into controversy between the crown and a subject, whether held in the right of a person who was the king or as representatives of the nation, The petition of right presented a judicial remedy. A remedy which this court on full examination in a case which required it held to be practical and efficient. There has been therefore no necessity for suing the officer or servants of the king who held possession of such property, which when the issue could be made with the king himself as a defendant. All right? Another reason of much greater weight is found in a vast differences in the essential character of the two governments as regards to the source of the depositories of power. Notwithstanding the progress which has been made since the days of the Stuarts, all right, and stripping the crown of its powers and prerogative, it remains true today that the monarch is looked upon with too much reverence, all right, to be subject to the demands of the law as ordinary persons are. And the king's loving nation will be shocked at the spectacle of their queen being turned out of her pleasures garden by a writ of ejectment against the gardener. All right, I'm going to read that again. Notwithstanding the progress which has been made since the days of the Stuarts in stripping the crown of its powers and prerogatives, the power was stripped when King George III, through the Treaty of Paris in 1783. All right, you seceded all the land that belonged to the crown. Okay, that was an unlawful, unconscionable contract. Why? Because the United States and the colonies had contract prior to that Treaty of Paris of 1783. All the lands that the United States has by way of acquisition of sovereignty, which is either by way of cession, conquest, discovery, accession, and all other forms, all right, which leads to the prescription. Notwithstanding the progress which has been made since the days of the Stuarts in stripping the crown, so that means that when the Stuarts stripped the crown, King James I, King James II, King James III, and they got their authority from who? Henry VIII, Queen Elizabeth I. That's who they got their start from under the Union of Crowns and the what we call the Union of the Crowns and the Treaty of Union of 1707. This is where slavery was brought over to the colonies as stated in Dred Scott case. All right. And it was adopted by the colonies as stated in the Dred Scott case. All right. The Stuarts stripped the king of his prerogatives, his jury regalia, which is the powers that you need and depend upon for you to have back for the return of your estate. All right. The crown remains the fountain of honor. You hear that? The crown remains the fountain of honor, and the surroundings which give dignity and majesty to its possessors are cherished and enforced all and more strictly because of its loss of real power in the government. It is not to be expected, therefore, that the court will permit their process to disturb the possession of the crown by acting on its officers and agents. Did you hear that? Did y'all hear that? I'm going to read it again. The crown remains the fountain of honor, and the surroundings which give dignity and majesty to its possessors are cherished and enforced all the more strictly because of the loss of the real power in the government. It is not to be expected, therefore, that the courts will permit their process to disturb the possession of the crown by acting on its officers and agents. All right? Under our system, the people who are called the subjects are the sovereign, i.e., the English subjects. All right? The English subjects. You must understand that. So with that in mind, let's go ahead. I'm talking about, we just started off, title to the property. The crown has title to the property because it's called crown land. Crown land is intel land. It's personified by the king. I'm your king. So I'll personify the estate. Okay? I am the representation of the as a trustee to the estate. Okay? Let's prove it. A basic understanding of fetal tenure. I don't have any problems with the YouTube. Fetal tenure. You hear that, everybody? We already went to the real estate book. Let me show you again. Sorry about that. As we see, all the English people are assumed to be dead. All right? So if we are assumed to be dead, then that means all these land and the state estates, either to the crown or the state of New Jersey. Okay? The state of New Jersey, as a colony called the province of New Jersey, was the crown. Okay? So it's actually the crown property because I proved the Provincial Council of New Jersey was the crown before it fell under acquisition of sovereignty under the so-called misnomer of law of discovery. They didn't discover, excuse my friend, shit. It was already ours. Okay? And they took it without compensation. How you gonna pay somebody with debt instruments? Okay? When the contract clause says gold and silver. All right? That's a result of eminent domain power. All right? We are all subject to what we call the eminent domain of the state. All right? Through their public governmental agencies. Okay? Which through the contractual agreements that they make as the creditors and us being the debtors, we already fall into the status as debtors. Okay? And we become the secured pledge as the real property or personal property that they're going to foreclose on real soon. Okay? They're going to foreclose on real soon. They're foreclosing on the real estate. Now they're going to foreclose on the people. Okay? And guess who's going to be at the rim, the hem of it? The sheriff's department. Right? The sheriff's department. All right? This is called adverse possession, prescription of sovereignty. Y'all better understand what's going on. This is the real game we're talking about. Let's prove this. Fetal tenure. Fetal tenure is the real. Fetal tenure is the real property ownership system in which ownership rests with a sovereign who may grant lesser interest in return for service or loyalty. Every estate held by a fetal tenure was subject to the forfeiture for breach of the condition of which it was granted. Breach of a contract. All right? Breach of a contract. This is law dealing with right of possession. Feudal tinkers had its foundation. Feudal tinker had as its foundation the principles or fiction that the king is the universal lord and original proprietor of all the lands of his kingdom, and that no man possesses or can possess any part of such land which has not been derived as a gift from the king to be held upon feudal services. Did y'all hear that? Did you hear that? The king is the original proprietor. The crown is the original proprietor, the original creditor, the original land grantor. You hear that? Everybody must understand. Everybody pull that up if you can get it. New Jersey, June 24th, 2029, 2009. This is that legal kung fu. Legal kung fu. You know what I'm saying? New Jersey Day. This is their website. Governor John, this is how public they are with this, all right? Governor John Corzine, Secretary of the State. You hear that? Secretary of State, Minister of Affairs, all right, of the state, Nina Mitchell Wells, and Commissioner of Education, Lucille Davy, invited citizens of New Jersey to join and celebrate New Jersey Day in observance of New Jersey's 345th founding as a British proprietary colony at the State Museum in Trenton on June 24th at 2 p.m. Okay, this is, of course, this past. Why is June 24th New Jersey's Day? All right. Background. Over time, the region of the Mid-Atlantic that includes our state has many names. It is believed by some that the descendants of the Indians who came here over 10,000 years ago call it the Lenapehoking. Lenapehoking. All right. Hence the word. You see the king at the end of it. Lenapehoking. All right. In 1524, the Italian explorer Giovanni di Verrazzano dubbed it Lorraine. All right. A century later, the Swedes call it New Sweden, and the Dutch call it New Netherlands. All right. We know Lorraine, it goes back to France. All right. All right. Hence, we're dealing with the French kings. But let's read forward. Nonetheless, let's read forward. But the name that has stuck is New Jersey, a term which appeared from the first time ever in a royal grant issued by King Charles' brother James Duke of York on June 24th, 1664. This grant established an English colony named New Jersey on the land bounded by the Delaware River, the Hudson River, and the Atlantic Ocean. That royal grant can be considered New Jersey's birth certificate. All right? New Jersey's first birth certificate was the royal grant given by Charles II. All right. A second birth certificate came on July 4th, 1776, when the representatives of the 13 American colonies created a new nation they called the United States of America with the Declaration of Independence. The colony of New Jersey became states within a new American nation. So we know this is an unconscionable contract because they violated the original contracting clause by what they call altering the original contract. Okay, you were not called states; you were called colonies, and you didn't have the authority to declare your independence from the contract. Okay, you were under contract. All right. So when you declared your second birth certificate, July 4th, 1776, and in the public, you're telling people that you broke away, but in the statute, you didn't. Okay, under the legislative parliamentary statute of New Jersey, you did not. Your second birth certificate was revoked because your first birth certificate was revoked. All right, by the name that it says that under letter patents can be charters can be recalled. All right, if they're violated under contract law. It said, but the name, myself. It said the first royal charter was granted and by Duke of York on June 24, 1664, which was the royal grant, which was the first birth certificate considered for the state of New Jersey. And the second one came on July 4th, 1776. The United States was even in the picture at that time, y'all. All right. So if we can disqualify the birth certificate, we can disqualify the first birth certificate, we can disqualify the second birth certificate. All right, so let's do that. That's the New Jersey website, Department of State. This volume is the most significant item included in the Christie acquisition, containing transcriptions of land grants, legal cases, correspondence with officials, including William Penn, and a record of the proceedings of East Jersey law properties during 1682 and 1682 to 1884. All right. The volume originally also had 5 maps purchased separately at the auction. 3 documents are shown as follows. King Charles II patent on 12th of March, 1664, top left, granting a vast expanse of the eastern seaboard to his brother James, Duke of York. The Duke subsequently granted authority for the land and governance of New Jersey to John and Lord Berkeley and Sir George Carteret. New Jersey's first colonial government, Philip Carteret, asserted ownership of the state of Staten Island based off the language of 1664 grant to Berkeley and Carteret, top center. New York governor disagreed, and the question was not fully resolved until 1834. In this 1634 letter to the colonists, top right, the king commanded the planters and inhabitants of East Jersey to submit and yield all due obedience to the laws of the government of the new proprietors. All right. March 12th, 1664. We know the proprietors surrendered their authority back to the crown. Okay. So these are the 3 documents they make a reference to. Boom, boom, boom. All right. These are the basis or the legal standing that the states have in lieu of them having right to these lands, which is the highest form of ownership in these lands is fee simple. All right. Which the statute says different. And that's a result of that which was ceded to the United States through what they call public domain. All right. Public federal lands. All right. I ain't going to go through that for the sake of time. We're going to move forward. All right. So we have the first birth certificate, which was the proprietors, the charter given by Charles II, the Duke of York, March 12th, 1664. All right? Which all the land tenures, manors of hereditaments were passed to the lords or to tenants in chief. All right? Under fiefments. Fiefments were contracts granted feudal tenures or estates in fee simple, all right, which is the highest form, because the other form is entail, which are exclusively left for heirs. Entail, all right? And then the second was January 14th, July 4th, 1776. So let's go to the legislative statute, okay? Present day, and see if these charters or these patents or these deeds are still valid. Okay? Let's see if they're valid. Because New Jersey is assuming that they are on their website publicly. All right? And when you read this without going back and checking, then you left up to that conclusion or that illusion. Okay? So let's go to the legislation. Everybody pull it up. Let's get the newer version. 2022, they haven't updated it. Everybody pull that up. Give me a second. We're coming to our close. Okay. All right. Back to fiddle tenure. It's all deals with property. Fiddle tenure has as its foundation the principle or fiction that the king is the universal lord and originated proprietor of all the lands in his kingdom, and that no man possesses or can possess any part of such land which has not been derived as a gift from the king to be held upon feudal services. Did you hear that? I don't think I heard that. Fiddle tenure is a real property ownership system which ownership rests with the sovereign who may grant lesser interest in return for services, i.e. contract, or loyalty, i.e. contract, i.e. allegiance. Every estate held by a fiddle tenure was subject to forfeiture, reversion, remandment, all right, for breach of the conditions of which it was granted from the original creditor, all right? No one knows who's the creditor here in the United States of America. No one knows who's the creditor here in all the states who make up the United States of America. The only person who's supposed to know is that are the citizens. And no citizen knows that because the citizens aren't being informed by those who are make up the body of politics. Okay? The body of politics does not care about their citizens, because if they did, they would inform you of what's going on. They're telling you, they ain't physically telling you outright, being like, yo, turn to channel 10 and 7, we're going to inform you. They just put it out there and hoping you stumble upon it. Okay? Where I'm actually informing my English subject about what's going on and what's taking place and what's going to conspire. Okay? Let's go to it. New Jersey Revised Statute 46:3-1, dealing with property. Property means possession. All federal tenures of states and the instances thereof taken away, discharged, and abolished from and after March 12th, 1664. This is when New Jersey was given their first charter. Where did it go? Right here. I see it. New Jersey getting the first charter on March 12, 1664, to the proprietors. They surrendered it back to the crown in 1702. It was called the New Jersey Provincial Council under the crown. Okay? So the charter given on March 12, 1664 has been abolished, discharged, taken away. All right? And it was also reiterated an act concerning those tenures passed February 18th, 1795, showing that those federal tenures are taken away, discharged, and abolished forever, and no such a state of incidence that has been given at that time shall be given there hereafter. All right? In whatever manner. All right. It says here, 46:3-2. The tenures, honors, manors, lands, and tenements, or hereditaments, or estates of inheritance at the common law, held of the King of England, or the person or body of politics or corporate. This is the king's true body. Okay? All right? If you're looking at it from this perspective, the abstract, you're going to be led astray. All right? The mystical body of Christ. That's what y'all waiting on. All right? This is what y'all waiting on. Right? The mystical body of Christ. Okay? This is what y'all waiting on. This is happening now. Okay? In the concrete. With the crown. This is actually happening as we speak. Right here. You need to understand English law to understand what's going on. Okay? Let's go back to the revised statute. So the tenures and the honors and the manors and the lands of hereditaments. Hold on for itself. The tenures and the honors, manors, lands, and tenements or hereditaments or the estates of inheritance at the common law held either of the King of England or any other person or body politic or corporate at the time before July 4th, 1776, is declared by the Section 3 of an act concerning those filtered tenures, passed February 18th, 1795, are now turned into free and common sockets from the time of the creation and forever thereafter, and shall continue to be held in free and common sockets. Discharge of all the tenures or fiddle tenures charged in instances enumerated as established in 46:3-1. Why? Let's see. Because all the gifts, grants, conveyances made prior to and after July 4th, 1776 of the estates of inheritance by the letter patent under the great seal of the state or any other manner by the state, by the legislators thereof, or by the commissioners or agents of forfeited estates, or by other lawful competent authority of the state, should be and remain allodial and not feudal, and should forever be and continue in free and pure allodium only, forever discharged of all fiddle tenures and the instances thereof, and all other services whatsoever. All right? And in closing, just go ahead. I'm going to end up with this. If y'all understand contract law, well, you will understand this. Corporations, associations, religious section, 61-28. Saving of rights under charters granted by Great Britain. Okay? We already read in United States versus Lee that the Scottish or the House of Stuarts, the kings of the Scottish crown, what it said, stripped the crown of its prerogatives. All right? So the prerogatives of the crown were left dormant and corporations in place thereof, as stated in Chisholm versus Georgia, because the king gives life to the corporations. All right? There's only two, the corporation sold and all the other ones, the aggregate. All right? So, and here is 16-28. It says, being section 12, an act entitled, an act to incorporate, personify, incarnate the trustees of the religious society of that Third Timothy English Church or God's Church, i.e., the English Church of England, according to the Magna Carta, that should remain free, right? Approved April 9th, 1875. Saved from repeal. Why? Because it's perpetual under the crown, because under the crown, provincial crown of New Jersey, it's perpetual. This section vests the property held under the charters of incorporation granted by Great Britain, i.e. the creditor, and corporations, i.e. the debtor, created in place thereof. Okay? You must understand what's going on. So in lieu of this picture here, You must understand this, that the property of the crown has been taken by the state of New Jersey, right? And I proved by the state of New Jersey statute that it still belongs to the crown and the king and the king's subject. It still belongs to you, all right? But you must come back as an heir. So there you have it. I hope that it was clear. Excuse my belching. I'm drinking coffee, so of course, that gas. So I gotta clear up on that. But other than that, once again, I love you all. You know, my job is not to get views based off ratings, but to get views based off those who searching for the understanding of who they are as English heirs and successors. Okay, all right, and just don't take this information and go back to sleep. All right, take it to where it means something. All the platforms that you go to every day, bring this information to them. Invite me to the platform, the podcast, other lectures. I don't mind. You know what I'm saying? Because my job is to change the minds of the people by changing their literature. All right. And changing the literature is not by writing new literature, but by exploring that literature that already exists. And who writes your books set your timeline, and time never was when the English people was not. And we know that goes back to what we call time immemorial. Going back to the time of the usage and the customs before it was written down. Okay. And with that, we here at the Third Typical English Church of England, on behalf of my moderator, Archbishop Belmont, and of course my queen, Sister Godwinson from the House of Godwinson, as well as all those students, Brother McCarroll, I give you a shout out, as well as Brother Milligan, exercise his 5 senses, right to travel on the King's land. I got you, bro. You know what I'm saying? That proclamation is in the mail. I issued a proclamation for all English heirs that they're allowed to travel on this land according to the Magna Carta, which prohibits search and seizures under the Magna Carta. Improper search and seizures, because when you're being searched and you're being seized, that's a violation of law, all right? Because they assume that you have a contract or agreement made with them that puts you in a position of a debtor, all right? Only debtors can be seized. All right, that's what foreclosure is all about. You don't pay your debt, they can foreclose on you. You seen it in the cartoon. Okay, he said it. Don't pay it, we coming for you. We taking everything you got. You don't like it, leave. Okay, we're not leaving nowhere. We're home. All right. So for all you people who love your English history, your English ancestry, your English customs traditions, please tap onto this site because this is your remedy. Freedom. All right. If Frederick Douglass knew this, and he knew it back there when we were enslaved, then damn it, you better follow it. All right. So with that, we here at the Third Typical Church of England says peace.